All right. Hello, everyone. Welcome to our webinar today, Arbitrating Diminished Capacity Issues in the FINRA Forum. Excited about this. Excited for the registration list. We have a great group of attendees, a really strong, large number, and a lot of familiar faces. We're going to open up the chat function. A lot of you guys, frankly, could be speaking on this panel. And so if you have questions, if you have thoughts, drop them in the chat, and we'll try to answer them or address them, or it'd just be nice to hear from some of you guys. So my name is Josh Jones. I'm the managing principal of the Birmingham office of Brettler, Amory and Ross. Happy to be here today. As you guys know, the firm is very active in the senior and vulnerable investor space. We do a lot of compliance work. We do a lot of regulatory work, and this panel is going to be a little different if you've attended some of the previous ones, because we're going to focus on litigating, focus on arbitrating, and what are some of those issues that you face, whether it's dealing with seniors or other diminished capacity issues. One thing that I've noticed in talking to people and working in this space is people seem to come at this from two different angles. One is you get a lot of compliance, particularly in AML. That's the background that a lot of people have. And then there are folks like me that come at this from a litigation aspect and a litigation background. And so, we're all, I think, working for the same goals, but it's maybe gives you a different perspective. And so what I did is I put together an article for the ABA Securities Litigation Journal, where I talked about some of these issues. It's available on our website. It's available on the ABA's website, and check it out if you'd like. Before I introduce our panelists, I did want to make a quick pitch for the ABA. The Securities Litigation Committee there is very active. We have a very active senior and vulnerable investor subcommittee that is co-chaired by one of our partners in New York, Larry Finster. We have a very active SRO and state regulatory subcommittee chaired by Andy Sidman. We have a securities arbitration committee that's very active. So there's a lot of different ways to get involved with the ABA. If you're interested, let me know. So that's who I am. I am one of the co-chairs also of the firm's seniors group. And we'll just go in order there. And Sean, introduce yourself, please.
Sure. I joined Brettler in 2011. I'm a principal in the New York office. I've been trying a lot of these arbitrations involving seniors for the past almost 25 years or so. Before I joined Brettler, I had 17 years at Morgan Stanley and at Smith Barney, where I was managing outside counsel and tried in excess of 100 arbitrations or so. And then before that, 6 years in the Brooklyn DA's office. So I think I've acquired a lot of trial experience dealing with a lot of different types of witnesses. And we're going to talk today about some of the prepping information and things you need to do to evaluate your cases, to tell your clients what you really think about the cases, and to make sure that your witnesses are forthright and get your story across during the course of a hearing.
And Joelle, it looks like you're in our new Dallas office.
I am. So good afternoon, everybody. Thank you for joining us. I'm Joelle Sims. I'm a principal in the Dallas office, formerly in the firm's Fort Lauderdale office for the last about 8.5 years, and still doing work out of there. My practice is primarily in the securities industry, retail customer and employment arbitrations, and I also do some commercial and employment work outside the securities industry as well. Along with Josh, I'm also co-chair of this firm's senior and vulnerable investor group. So excited to have this discussion today and to hopefully hear from you guys. As Josh mentioned, if you have any questions or any points of discussion you'd like to hear us talk about, please don't be hesitant to bring that up in the chat or the Q&A function.
And Eric, let's take you out of order because I want to save Andrew for last. Would you introduce yourself and Capital Forensics? I'm sure most people know who you guys are.
Sure, thanks so much. Eric Cyber, I'm a managing director with Capital Forensics. I've been with the firm 5 years. As you probably know, we provide the full gamut of litigation support tools and regulatory compliance consulting to firms and counsel. Prior to that, I spent 35 years at some of the larger Wall Street firms in every capacity, front office, from broker to head of retail sales. And of late, I've been testifying with Capital Forensics as well on cases including issues involving dementia.
Great. Great. And Andrew, certainly last but not least. Oh, I'm having trouble hearing you. Can you guys hear him? You are too.
Can you hear me now?
Perfect.
Yep. Thanks.
Sorry about that.
No worries.
My name is Andrew Mounds. I'm a member of the firm's. I'm an associate with Bressler in the New Jersey office and a member of the financial institutions practice group and the senior and vulnerable investor practice group. I'm also one of the individuals responsible for the upkeep of the Bressler Senior Map, which many of you are probably aware of. But for those of you who aren't, the map is a comprehensive state-by-state guide for broker-dealers and investment advisors that really covers two primary areas: firms' reporting obligations under each state's law and firms' ability to place temporary holds on transactions and disbursements under each state law. There's a lot of legislative action in this area. We're now up to over 30 states that have laws specifically targeted at broker-dealers and investment advisors, and we expect that number to balloon further this year. We track these laws on a daily basis, and we update the map almost as often. And just as a sample of what you'll find when you go to our website, you'll have contact information for each state agency where you have to report. You'll have information about how to secure civil, criminal, administrative immunity for reports and holds, and clear steps that should be taken after you place a hold. And the best thing about the Bressler map is it's free.
Well, Andrew, we appreciate it, and I don't want to make a pitch for the map, but I do want to make sure people are aware of it. And a lot of the issues that we talk about today are going to relate to the various report and hold laws, the various obligations, and some issues in litigation with those. So today is here's what we're going to look at. We're going to talk about generally the type of FINRA claims where you might see diminished capacity issues come into play. We're going to look at what I still call the new FINRA rules, although frankly at this point I don't think that they really are that new, and certainly most of the people on the call here are going to have some familiarity with them. We're not going to discuss really in detail the rules and the rules obligations. Instead, we're going to look at more of the litigation concerns that are arising from those. We're going to talk generally just about kind of the sensitive nature of diminished capacity issues and dealing with those in an arbitration setting. We're going to talk briefly about trying to keep the money if you can before you let it go out, and then just some kind of general trial tips about what we've done and things that we've undertaken to help win cases. And so one thing we want to talk about before we get started, kind of to set the table, are the types of claims and what we're seeing coming down the pike. Joelle, what are we looking at here?
Sure. So it probably comes as no surprise to everyone who's on the webinar today that litigation in FINRA involving elderly and elder vulnerable clients is certain to increase significantly in the coming years. And that's for a number of reasons. Number one is the aging investor population. You've got the baby boomer generation with a substantial amount of wealth, and people who have this amount of wealth getting older and facing these issues that we are all likely to face as we age. The second is unique vulnerabilities that happen with aging, with cognitive impairment, whether that be due to dementia or becoming more senior, or even with substance abuse too. We talked about that in one of our prior webinars, having people who are dealing with cognitive impairment issues, and the substantial amount of wealth. There's a lot out there for the taking, and a lot out there that whether it's the heirs, whether it's someone looking to exploit an elderly person. There's a lot more at risk there. And so, we see this trending upward. I think in past webinars, we've talked about the fact that, that's not necessarily indicated by the FINRA statistics, although the FINRA statistics only cover where there is an express claim of elder abuse. And in my experience, and I would assume most of the other panelists' experience, as well as the people on the call here, the vast majority of times that this comes up, there's not actually a claim for elder abuse. it usually comes up more, and sorry, my lights go out. I have not been able to fix that in the new office here. But that usually comes up in the context of not a separate claim, but just, this was unsuitable because this person, wasn't capable of understanding it, or you should have been on the lookout for this particular child who was encroaching in and sort of inserting themselves in the relationship, as opposed to actually claiming that the firm itself engaged in elder abuse, or the financial advisor, him or herself, engaged in elder abuse.
Yeah, and I think certainly the SARS reporting is reflective of an increase.
Yeah, and so the SARS reporting, this is an interesting kind of trend that we see here, not unexpected, but basically the EFE, or elder financial exploitation, was added as an electronic category that you could check when making a suspicious activity report. And so that was added in 2012. As you can see, it's just been pretty lockstep increasing from 2012 over the last 8 years through 2020. And one important thing to keep in mind is this is only by securities firms. This doesn't even touch on the EFE SAR filings from banks or credit unions or other financial institutions. So it's fairly significant.
Yeah, and one thing I've noted about this slide, and when we've talked about it previously, is looking at, if you break down the SARS filings by geographic, breakdown either by state, or there seems to be some underreporting in several states where, if you look at just on a percentage of population, I mean, obviously there will be states that have, greater senior populations, but you would expect to see, some consistency with respect to the filings. And I don't know if that is due to, state regulators being active or what, but there certainly seems to be some states where, you're seeing a substantial number of SARS filings, and others where the numbers seem to be lower than what one would expect. And Eric, Joel briefly touched on this, but, you guys obviously through, the ARB reporter closely follow what's going on with FINRA awards, and have easily compiled statistics that you provided some here.
Sure, thanks, Josh. So as Joel suggested, we are seeing an increase in filings that name some type of dementia, elder abuse. These results are based on a search of 10 or 11 different words that could indicate the issue. And FINRA only began tracking this statistic as a new category for the full year in 2018, which is why we're just showing for these 3 years. Interestingly, keep in mind that though the total number of FINRA elder abuse cases filed is by year, the awards don't necessarily reflect that number from that year. As we know, so often it could take a year, 2 years for the case to be heard after the case is filed. But as a percent of what's filed versus or actual awards, and these are quantifiable awards. So they exclude settled cases, stipulated cases, or any cases where there was an unspecified requested amount, or in fact, the case was dismissed by the claimant. So you could see that despite the large number of cases, which, 200 cases for the year or so for each of the 3 years where an elder abuse issue is raised, less than 9% were decided by a panel. So we can see that these cases are either being settled quickly, or perhaps are have an unspecified requested amount, or actually are being dismissed. And from that, from the number of cases that actually had awards, in all 3 years, more than half of them had 0 awards. So Claimants Counsel is using it as one of the many descriptors of what was wrong with the situation. And the panels are finding in favor of the respondent in terms of the 0 awards. Similarly, if you go all the way to the right, while compensatory awards have been, 15% of the requested amount, 5% in 19. What's very interesting is the low number of punitive awards which are being awarded. And there you could see the requested amounts, 7.2 million, 11.3 million, and they had 20,000 and 0 respectively in 2019 and 18. So while punies are being requested often, they are rarely being awarded. And you could see how many of the cases that are filed are actually and have awards are actually coming out with 0 awards.
Anyone have any thoughts on that low punitive number? It surprises me a little bit. I know arbitration panels are generally not looking to award punitive damages, and certainly in a lot of cases they're not supported by the law. But I don't know, in these type cases, I'm a little surprised that number is not a little higher. Although I guess if you look at 2020, they awarded effectively, what is that? 25% of requested punitive. So
yeah, well, we actually have a comment from Don Littlefield, who's my partner in the Dallas office here, who says the reason for the low punitive cases is the bad cases are settled. I think there's a lot of truth to that. And obviously when you're evaluating awards, you have to keep in mind that statistically speaking, most cases do settle. Out of the total number filed, most do not go to hearing. And generally speaking, if the cases, are really good or really bad, they're more likely to settle. If they're somewhere in the middle where there's room for interpretation, those are the ones, generally speaking, more likely to go to hearing. And, where there's more room for interpretation, I think you're less likely to see punitives awarded because there is kind of that gray area. So I think there's a lot of truth to that. And thanks, Don.
Joelle, also, we do a lot of EDR work, early dispute resolution with some of the firms. And what we also see is a lot of the cases are just being denied and then they go away and they don't even become fully filed cases. So it's kind of interesting to see, what's being heard as an end result.
You're saying firms denying the customer complaint?
Correct.
Right. Yeah, and not filing. Yeah, certainly see a fair amount of that. Well, some do get filed, and here's kind of an outline, Sean, of some of the types of cases that we're seeing.
Sure, and it's a pretty typical outline that I think you see across the board in terms of financial elder abuse claims. That generally is a state-by-state issue because elder abuse is defined differently in different states. I remember when I first started defending cases and somebody was 60 in Florida and elder abuse was alleged. And I thought, that's insane. That can't be because my parents are older than 60 and they're not old. But we've seen that over the years, many people on the claimant side sometimes allege that because they seek additional damages that can be there. I think more commonly across the board, and it's similar for elderly people, are the financial suicide cases and the failure to prevent loss matters. And those are when a older person, and I recently had a matter where somebody retired from their job. They had a very profitable business in the Chicago area. And they started really trading their account on a very, very active basis. And they then, as the brokerage firm was talking with them about turning the account from a commission-based account to a fee-based account to cut down on the costs, the man died. He had a heart attack. And we then heard from the wife and the children about it was a financial suicide. And you should have known that, my dad retired and my father didn't have didn't have the capacities he used to have. And the case came in and we did our due diligence and we helped our client out with that one. Mm-hmm. The next one area that we see a lot of are the heirs, if you will, coming in and alleging after somebody has passed away that they were really entitled to the claims, that the financial advisors were somehow involved in making or assisting one heir get the assets over another heir. And most of those areas are dealt with in court, in probate type disputes, but that's been a growing industry, if you will, as we realize that so many older people really have all the wealth in this country.
Well, and Sean, we see a lot of those cases, like you say, that start in court or start in probate court, and then the firm will get brought in. And at that point, you've got to kind of make a determination about, hey, are we going to stay in court or are we going, to take this to, as we have the contractual right to do, to a FINRA arbitration. And
Josh, that's exactly the issue. Right. It's like you really need to make a determination of what involvement did our financial advisors have in these decisions. And, if they were involved in some ways, oftentimes it might make more sense to wind up in the arbitration forum versus staying in court.
Yeah, and we got an audience question about, I believe this is going back to the financial suicide, about whether that would apply to unsolicited orders. And, I'll start and then the other panel members, chime in. But yes, yes, I've had specific cases where it was an unsolicited, self-directed account. The woman would occasionally call in, asking questions or having trouble placing the trades online or so on and so forth. And they made those allegations, basically, that someone should have stopped her, someone should have known that she didn't have the capacity to do this. So yes, those come in even in unsolicited circumstances. That doesn't mean that they're great cases, but certainly there's a lot more unique defenses when you're handling self-directed accounts and unsolicited trading than when you're not. And I would say specifically in unsolicited trading in traditional brokerage accounts, you oftentimes will get the argument, well, that was mismarked. It really wasn't unsolicited. The broker was doing it and he was mismarking the trade.
Right.
So,
and then you have to go and look at what the broker did with other clients with the same stocks and see if there's a pattern or a practice there to mark those trades unsolicited. And if that's a one-off situation, you can do well there. But what can also happen there in these claims is the argument that the trading was generating so much more commissions than it had been before. The brokerage firm was happy with the additional commissions and they turned a blind eye to the trading. So you have to be mindful of that as well.
Yeah, I think that's right, Joel. I mean, they're definitely weaker claims or weaker claims under the law, and frankly, weaker claims under the equities. But they do get brought.
Then we get to suitability issues raised by the estate. And these are often more difficult because the estate, oftentimes, nobody was involved in making those trading decisions. And you've got to hope your financial advisor isn't so much of a contemporary as the individual who just passed away. And hopefully, because your defense of that is going to be all based upon who that financial advisor and his team was. I'm going to skip to the last one before we get to wrongful prevention. Financial advisors is now really an issue you have to think about too, because so many of the elderly clients who have brought these actions tend to have elderly financial advisors. And you really need to be mindful that the same issues that might be affecting the client's capacity also affect our broker capacities. And people, just like they're very good at hiding issues with their children, there are financial advisors who might be having cognitive issues who are also astute enough to hide it from management, to hide it from all but very close team members. So when you're defending these cases, you've got to be mindful and ask yourself, are there issues there?
Yeah,
and then last,
real quick on that point, I was not involved, but I know that the firm did a webinar basically on that topic, including employment concerns to watch out for and things along those lines. I think we have a recording of it, so if anyone is particularly interested in that topic, certainly reach out and we can give you some.
Yeah, and that one was I moderated that one. That one was recorded. We had a really great panel with regulators, firm representatives. So if you have some interest in that, there was a lot of really interesting perspectives on ways to deal with that. To kind of prepare yourself for any inevitable litigation. So definitely get in touch with one of us after if you want the link to watch the recording.
And then the last one is, issues where they're alleging that the brokerage firm actually stepped in and stopped the customer trading and stopped the customer from making distributions, and claims that, we shouldn't have done that. And I think Andrew's going to get into this area now.
Yeah, hey, real quick, Andrew, before we go to the next slide, I just want to briefly outline, I think this is a really interesting topic, kind of investor autonomy. And, we saw it with the GameStop stuff last week. What obligations, if any, do firms have? And, what are their liabilities if they take steps to try to protect someone? And, that comes back to, to bite them, who's responsible for that? And, I had a case for a large firm where they wanted to transfer money out to make an investment in a business that, literally made no sense. I mean, it was a terrible decision. And we had some concerns about the client's capacity, and we put a stop to the transfer. And, but, what happens if that business becomes Google or GameStop? I guess GameStop's a bad example at this point, but an investment that triples or quadruples in value, and in hindsight, preventing them from doing that ended up being a terrible idea. So I think that's something that regulators are looking at. It's something that firms are considering. And Andrew, it's something that the FINRA rules are, trying to get involved with as well.
Yeah, absolutely. And GameStop actually can be a good example of how firms can get tripped up under the transaction hold rules. If you imagine a scenario where last week a client came in, wanted to sell GameStop at $350 a share, for whatever reason, the transaction is held, and 15 days later, the investigation reveals that there was no financial exploitation, and the firm allows that transaction to go through. I haven't checked GameStop's price today, but it's not $350 a share anymore. So you're looking at potential large losses, and you have to look at a claimant's counsel when that claim is eventually brought is going to pick apart why you made that call, why you made that financial exploitation call, and whether your hold was authorized. And you start with the FINRA rules, and FINRA rules at the moment, Rule 2165 does not permit transaction holds. It only permits disbursement holds. So in that scenario, you wouldn't be authorized by the FINRA rule to make that hold. That might change soon. FINRA has issued a regulatory notice seeking to extend the rule to transaction holds, and that would actually bring the FINRA rules more in line with the current trends in the state laws. So if you're in that scenario, you should check the state laws. Many states allow transaction holds, and it's definitely a growing trend amongst the states. I looked yesterday, I think I'm not sure exactly how many passed laws in 2020, but I think the last 4 states that have included transaction holds. But even if you're authorized to place a transaction holds, there's additional issues, right? If your client's in Florida, there's certain training requirements, there's policies and procedures requirements in order to take advantage of certain immunities for placing that transaction hold. So you'd imagine in an arbitration that each of your policies and procedures dealing with this topic and all of your training dealing with this topic is going to be picked apart to see if the claimant's counsel can undermine that immunity that you got under the state law.
I think it's an issue that we haven't seen yet, but that we're going to see. I mean, discovery directed to trainings, discovery directed to the policies and procedures, discovery directed to, the way the rule is set up, someone makes this decision to put a hold into place. And, that person is, I think, very likely to be a witness, or at least, be subject to discovery.
Yeah, and we have an audience question who asked, have you ever seen cases involving the distribution of assets to family members while the client was alive, and then having people come back and challenge those after the client's death as not being authorized, or being the person being incompetent? And the answer to that is yes. And so that's why this is a really tough area. And there's, as Andrew was talking about, I think the GameStop phenomenon is probably not what you're typically going to see when you're making a decision as to, do we place a hold on this transaction or not? I think there's a lot of risk in doing nothing, because there are these laws, because there are these rules. If a firm fails to place a hold, I think you can start seeing, the claimant's attorneys come back and saying, well, you were able to do this, and why did it?
The safe harbors are designed to protect us, or our clients. But I also think you're right, Joel. They set up a bar as the minimum standards of what we should be doing.
Yeah, and I think we're going to get into this a little bit later as well, in terms of sort of preventative tips and what to do pre-litigation. But this ties into if some distributions happened, and then after the fact, someone's coming back and saying, well, my dad really wasn't competent to do this, or my dad was being, exploited by the person to whom these transactions were being directed. That goes into the analysis here. Is your field trained to spot red flags? Are they escalating those red flags? Are those red flags being reviewed? And if they warrant, are holds or restrictions being put in place while those are addressed? So yeah, absolutely, that's something that can happen. And that's part of the reason why complying with these rules and having a process to spot these issues, escalate them, and investigate them is so important.
I think that question raises 2 interesting issues. One is to go back to the investor autonomy. If this person is capable of making binding legal decisions, they can do whatever they want to with their money. And it's not necessarily our task to determine who is competent and who is not competent. If they want to give their money to their son and cut their daughter out of everything, that's on them. That's their decision. And so in some ways, I think firms and regulators are looking to protect investor autonomy, but then at the same time, if you've got a situation where someone is being exploited or pressured, where's the line between being pressured or feeling a familial obligation to support the son, and when does that become exploitation? So I think that's a very dangerous factual circumstance that we see on a regular basis. And it also goes to the point that you guys raised earlier, which is, are these rules now something more than permissive? If you're permitted to put a hold on, do you then have an obligation to do so? I would certainly argue no, you don't. You don't under the FINRA rule. You do under some state rules, and you need to take a close look at that. But I think you're going to hear arguments from claimants counsel that, like you said, Joelle, these set a standard, and if you fall below that, you're subject to potential liability. And Andrew, that raises the point, with the map and everything. Some states have requirements where if you have a reasonable belief that exploitation is occurring, has occurred, or will occur, then you have an obligation to report. Whereas under a lot of states and under the FINRA rules, you simply don't.
Absolutely. And these are really difficult. These are really difficult calls for firms to make. And one thing you can do to proactively that'll be good evidence in a litigation is to report to all applicable agencies. And as Josh said, FINRA has the trusted contact person rule. So you have to make your reasonable efforts to get the name and the contact information for that trusted contact person. But beyond that, if you look at the states, many states allow firms to contact third parties well beyond the trusted contact person, and usually it's worded something like people reasonably associated with the vulnerable adult, and that opens up a whole lot of people that the firm can contact in scenarios where there either is no trusted contact person, maybe you suspect the trusted contact person was involved with some of the wrongdoing.
Yeah, and this is so important, and not to kind of oversell the map here, but use the map. It lists out which states have this, and I had a case recently where there was an 87-year-old client. He showed up in the branch one day with the 40-year-old home health care aide of his deceased wife 2 weeks after she died, with a marriage certificate saying they'd been married. And about a week later, she showed up with a POA, which was deficient in and of itself, but showed up with the POA saying she wanted to liquidate all the assets, transfer it out to a bank, and a video of the guy in the ICU. So, then when that was rejected, and obviously the firm in that case put a risk restriction, and after that was rejected, then the guy called in to make the same order to liquidate all the assets, transfer them out. And when management tried to call him back, they could not get a hold of him on any number or in any means. And so, at that point, obviously the firm reported. Part of the conversation was, kind of earlier on when the marriage first happened, the guy initially gave permission to the firm. He didn't have a trusted contact, but said, yeah, you can contact one of my daughters. When the new wife got upset about that, he said, never mind, don't call any of my family members. And so in speaking with the client on this particular issue, this was in Texas, which allows the firm to reach out to any person reasonably associated with the vulnerable person. You don't need permission. They don't have to be a trusted contact. If they are reasonably associated, it can be a child, it can be a family member, it can be a CPA, it can be an estate planning attorney, someone who's reasonably associated to reach out and say, there's something fishy going on here. That's huge, because the goal in these cases, and this is, kind of getting before it's is to avoid litigation, obviously. But it's not up to the firms to make a determination, is this person, do they have capacity or not, or are they being exploited or not? That's not for the firms to decide. The goal is really to kind of raise the red flag and let, the family members, APS, the entities that are, in charge of making these determinations, give them the ability to do that before the money is gone. And so in this particular case, one of the daughters who had been consulted previously filed a report with APS actually before the firm did. APS got involved. The sheriff's department came and investigated. The woman's currently in jail. There's an ongoing guardianship action, and so now with the court case, there's an order indefinitely freezing the accounts. And that's ultimately the end game, to have something from a court or to have something from the police department or something that's saying, don't let anybody touch this money until we've made a determination. So, that's checking out this stuff and seeing what abilities you have under each state is so important. And one other point I'll add, I know we've been on this slide a long time, but there are a number of firms who are starting to include in their opening account agreements the right to restrict the account, basically if they believe there's suspected abuse, exploitation or fraud. And so that kind of gives you, the ultimate permission outside of FINRA, outside of, the state statutes, that if the client has agreed that you are allowed to restrict their account, if you think there's fraud or funny business going on, that gives you the broadest protection. It's not going to be statutory immunity, but it's going to be, real compelling evidence if you have to get to an arbitration on it.
And Joelle, I think your war story, highlights a lot of the sensitive nature of these issues and a lot of the problems that you face when litigating.
Yeah, it does. We should probably give the code, Josh, before we go forward.
Yeah, absolutely. Thank you, Sean. Thank you. So the first CLE code is Bressler, B-R-E-S-S-L-E-R.
That will be hard to remember.
And just real quick, Sean, and I'll let you answer this one because I know I've been talking a lot. We got an audience question about whether we've been using interpleader actions in these types of circumstances. And if anyone, Sean, if you want to weigh in or anyone else,
we'll circle back to that on the later slide. But yes.
Okay. Yeah. So we all have to be very mindful that these issues are quite sensitive, and they're sensitive both to the potential victim, the elder person being exploited, to that individual's spouse, to that individual's offspring. Whether we're dealing with the situation where assets are about to be taken out of the door because the account is still active, or once an arbitration or other litigation has commenced. And it's important, I think, to deal, despite the fact they're adversaries, to deal with those issues on a very respectful, careful basis. And I think also it's important to be mindful that many of our arbitrators are potentially aware of other individuals who have suffered from Alzheimer's or know of people who are suffering from dementia. And when you're presenting your case, I think we've got to be aware of that. And oftentimes, I know for myself, I've got a mother-in-law who, has these issues. And I think many of us do that. And it's important to be respectful and not turn around and be dismissive of the situation there. And you really hurt yourselves if you don't treat people in that type of respectful manner.
Yeah, these can be tough cases to try. I mean, any case where you're dealing with someone's life savings or things along those lines can be tough, but these can be particularly problematic and particularly emotional. They're in some ways it can be similar to divorce cases where emotions can be high. There can be a lot of internal family dynamics at play. I had a pro se claimant cross-examining his aunt on the stand, and he asked his aunt, why didn't my mama love me? And I mean, I've laughed telling that story, but it's really not funny. And the arbitrator, the chair of the panel, to his credit, said, Mr. So-and-so, that's a question better asked of your aunt, over a cup of coffee or something. This really isn't the forum for that. But I mean, that's kind of what you're dealing with in a lot of these issues.
Years ago, on that same note, I had a daughter and a son of an older woman who basically, they convinced the older woman to bring a claim against their broker. But as we dug through things, it really turned out that they were jealous of the close relationship that had developed over the years. between this woman and the financial advisor, because those two spoke all the time. And the son and daughter lived around on the other side of the country and never spoke with their mother. And those other factors really exist, and you've got to be mindful of them when you're evaluating these cases. So we should probably go to the
absolutely. Yeah, I want to keep moving forward because we're running just a little behind. And Eric, obviously, the best thing to do is to avoid litigation if you can, and certainly take steps, pre-litigation to protect yourself if possible.
Absolutely. So, having run a large complex for a large firm, we handle these issues quite often, and you need to make certain that the manager is involved. The manager needs to manage the office by walking around, knowing his or her financial advisors, and remember that when the cases actually come and they're finally heard, the state or the cognitive state of the claimant, it could be materially different from the state of the claimant 5 years ago when they started trading with the financial advisor. And the dementia could start out perfectly fine with minor issues that nobody suspects, and by the time the case finally comes into before the panel or into court, suddenly you have a very, very disabled person, mentally challenged. And it's really critical that supervision notes, customer contact notes are maintained. We just finished a case now where the client had the financial advisor, I should say, had phenomenal notes on every conversation he had with the clients, husband and wife, and that really helped him out really impressively to end up with a 0 award, and mostly because his notes were so good. And where the notes weren't perfect, there were enough supervision notes. There were customer contact notes from a risk manager to say, do you know everything that's going on? Do you see? So if you have clients who, I'm not sure age 60 really qualifies as a elder anymore, probably because I'm in that category now, but I think that if you have a client who you suspect could be not necessarily getting in, and you can get that from simply a phone call. I had another case where the client once wrote me a note as the manager saying, my financial advisor did a trade and I never spoke with him or her. And I happen to know the financial advisor very well, and I knew that couldn't be the case. So I simply put in a policy, next time you have to do a trade with her, just have her call me or transfer her over to me, and I will confirm the trade with her. And I made note of those notes. So the manager plays a critical role in litigation. The financial advisor plays a very critical role in litigation. And the best thing you could do is make sure, if you're within the firm, whether it's compliance role, risk manager role, financial advisor, or complex director, that you are taking good, copious notes, because those will very, very much help you later on.
Yeah, and that's really in kind of any context. This is the free advice coming from the lawyers here, but especially when you have elder clients, because sometimes a case that you don't think involves capacity issues, by the time you get to a hearing, it does. We had one case where the challenge was about the complexity of the portfolio, that they were in, a variety of annuities, they had hedge funds, they had this sort of leveraged strategy, claiming that it was unsuitable and complicated. And we got to the mediation, and this guy, who the financial advisor said was, super experienced, very knowledgeable, was directing all these transactions, was having capacity issues, and, was really not able to remember a whole lot about his own life, let alone, these complex strategies. And so, having notes where it shows, who the panel is seeing today is not the client that was the one making these decisions is critical. And can be a big game changer when you get to a hearing.
What I find with notes, oftentimes if you have an older financial advisor, you might not have the notes that you might have with somebody who's younger and in the business, because they've been around back in the day when the confirmation and the monthly statement were the record of what happened. And oftentimes these older financial advisors don't have the email exchange with their clients as well. So you then have to look at other ways to corroborate what was going on. And that goes into interviewing, the other members of the sales team.
And Joelle mentioned earlier, suitability issues are often come about after the client perhaps passes away. And certainly the notes help at the time. Make sure that your investment objectives are accurate. Make sure that the client's risk tolerance is accurate so that you could say to the children, look, this was updated in 2019. So your father, your mom, whomever it may be, knew certainly well what was going on. They were the ones who requested it. They signed the document. And I will tell you that I had 2 or 3 cases now that I'm thinking back on it, where the financial advisor did not suggest that the client was had any kind of dementia, but the kids were calling in to say, please do not trade my father's account. He has dementia. And this went back and forth. The client was, this is my money. And the kids were, no, he doesn't have the ability to do it. And finally, we just froze the account and said, go to the courts. Let the courts determine the capacity of the client. And whatever they decide, we're happy to follow. But don't, my advice, not legal advice, but just practical advice from having run a large complex is don't be the jury on this. You can't, most financial advisors and even managers are not equipped to determine the suitability, the dementia capacity of the client. And therefore, the best thing you could do is say, bring it to the courts. If there's a family dispute, let the court decide whether or not the client has the wherewithal to run his or her money.
And Eric, that's a perfect segue into the next slide, which is, where is the money? And Andrew, when we cover this, let's be sure and touch on the question earlier about the role of interpleader.
Sure. So, we always recommend that firms err on the side of caution, which means keeping the money rather than letting the money leave, because the exposure does increase substantially once the money is out of the account. And the firm has a lot less control once the money is out of the account. It's a much better fact pattern to go into an arbitration to still have control of that money. There are ways, like Josh said, to get a court involved, to file an interpleader and ask a judge to make the decisions about what the firm should do, rather than the firm sitting there and trying to make decisions about who of a number of parties should get money, whether there was a capacity issue. Firms should always act quickly in these scenarios. The money can leave the account quickly, and then once the money is out of the account, it can disappear very quickly. And as I said before, another big thing with these rules is making sure when you contact somebody, a third party, a trusted contact person, that you're not furthering the problem. If you contact the person that took the money, that money is going to disappear even quicker than it would if you didn't contact them. It's a good reason to keep notes on all of these contacts.
Once the money leaves, it's basically gone. And certainly that's true in the case of a fraudster, someone like the home health care aide or the Russian bride, or someone who is, intentionally trying to defraud a customer, that money is obviously gone. But even in the family situation where, you've got competing interests by the kids or what have you, once the money goes to the third party, whether it's the child or whomever, they spend it and it's gone. And the chances of you being able to third party in and say, well, actually, this person has the money and they should be liable, makes it a lot more difficult.
Yeah,
and when you were,
I'm sorry, I would just comment on the interpleader. Interpleader is a great tool where it can be applied, and obviously it depends on state statute. But typically, you're going to need a dispute as to ownership or claim to the funds. So where you have a circumstance where, for instance, going back to this guy with the deceased wife's home health care aide, there wasn't any, we couldn't interplead in that case because there wasn't any dispute as to who owned the funds or claims to the funds. The dispute was, is this guy being exploited, number one, and then later on, when the guardianship action was filed by his daughter, does he have capacity to make decisions? And so in that instance, there's really not a legal basis to interplead, which again, getting, not to sound like a broken record, but getting back to the trusted contact, kind of the best outcome in that circumstance is to have someone close to the vulnerable adult file a guardianship or some other legal action to get some sort of direction on, does this person have capacity? Should they be allowed to make their decisions, and get a court order telling the firm, yes, they do, or no, they don't, or, here's what they can or can't do. And there are some states, and someone else, maybe lives in a jurisdiction that does this can speak up, but there are some states that allow the firm or any person to file a guardianship action. You got to be real careful about that, though, because a lot of those statutes have prevailing party fees. And if the person is deemed not to be incapacitated, the firm can get hit with fees in that instance. So
I was going to ask that question. Have any of you guys seen firms do that? I mean, I think it's pretty rare, but I think in the right circumstance, you're kind of damned if you do, damned if you don't.
It is rare, and it's rare just because of what Joel stated, because of the potential of, what you think is you're making the right decision in earnest, and lo and behold, that it doesn't work out. So.
Well, we made it to winning cases, because that's obviously the ultimate objective here, and we've got almost 10 minutes to talk about it. So I'm pleased with kind of where we are. And some of this we've already talked about. A financial advisor is going to be a key witness. Joel, Sean, they're going to be relied on in large part to tell our side of the story.
Well, that's the case really in any FINRA arbitration, right? But especially here, because you may not have the exploited individual, or you won't have that individual around to cross-examine. And so you're really going to have to make sure that your advisor can really tell the whole story, the who, what, where, when, and why. And if they can't, you need to advise your client about that sooner rather than later. And I've always believed that if you thought a witness was going to be on the stand for let's say 3 hours, the rule of multiply of 3 and spend 9 hours with that witness beforehand to get to, so them, so that they can answer tough questions, so that they have a real good recollection, because too often witnesses think they remember something, but when they're really pressed under pressure, you discover they don't. And so you've got to have a lot of confidence with your advisor before you put them on the stand, or you really are not going to do well with this case, because you're not going to be able to tell your side of the story through cross-examining the claimant who made the decisions here.
And Eric, I think some of the pre-litigation steps that you were talking about are really efforts to bolster the FA, whether it's through the notes or whether it's through having the manager come in and be able to support the FA's testimony by similar conversations that they had with the client.
Absolutely. And I will say that for managers who might be on this call or compliance people, if a client, now of course it's a little different with COVID, but if a client's in the office, it should be the manager's responsibility to at least go over, make some small talk, and take some notes on the state of the client, so that going forward, even you as an objective third party will have something to add as a witness to the case.
So I want to get out the second CLE code. The second CLE code is seniors. So seniors. One of the issues in these cases are the discovery can be a little different than your typical FINRA arbitration. I think you're going to want to do conduct discovery on document. Was this guy signing, taking out loans? Was he filing and signing his tax returns? At the same time, they're now claiming that he was incompetent. Was he, self-directing trades with an online broker during the same time period? So I think you're going to want to conduct some discovery on some of those document issues that may be a little broader than what we might do in a typical suitability case. Joel, go ahead. Yep.
The other thing there too is oftentimes there's estate planning going on, and you can go back and say to get the estate planning attorney involved in the case, because they're not going to put together those documents if they didn't think the person was of sound mind. All right. And if that was done contemporaneous with when the trading that is now alleged was bad is done, that's very good evidence that the person was of capacity and did understand what they were doing.
I think estate attorneys, to the third bullet point, potential witnesses who knew them over time, estate attorneys, CPAs, frankly, neighbors and things along those lines. But I think estate attorneys is one that could be valuable in the right case.
I also think children and the spouse are valuable there, because they're going to come in and tell the story, for example, about how the capacity was diminished at the end, and they might exaggerate over a longer period of time, but you can bring that same individual through how the older so-called exploited person built up their wealth, how they made all these decisions to build up this very nice lifestyle for the spouse and for the children, and kind of show a panel that, you know, who you're talking about was a very successful individual and understood what they were doing. And you've got to be careful about it. You've got to be respectful about it, but you can really lay the cards down there through those other witnesses. And it's something I don't think a lot of people will even see coming.
And speaking of being careful, Joel, that kind of raises the point we were talking about, medical records.
Yeah, medical records are important in these cases where there's allegations of incapacity. And I'm going to get my light fixed eventually here. But, you know, they can really be a double-edged sword. So, you know, if let's say the kids are coming in and saying, you know, my mom lacked capacity, she wasn't able to make these trades. And you've got a doctor who's going to testify who has medical records saying she was sharp as a tack. You know, that's really helpful. On the other side of that, though, if you've got, you know, the FA and the branch saying, oh yeah, this guy understood these trades, he understood, you know, that we were doing this leverage strategy, he was completely with it, and you get hit with doctor's notes saying, well, when he came in to see me, he couldn't tell the difference between a circle and a square, you're going to have a lot of problems trying to prove to a panel that you know, the FA and branch's view of this guy was the correct one. You know, when you've got a doctor who presumably is a disinterested third party saying, you know, this guy was totally out of it. So really important in terms of a pre-litigation and pre-trial you know, strategy to, if this is an issue, get these records up front, because they are, you know, going to really play into the evaluation of the case. And is this something that we can put before a panel, or is it not?
And Andrew, the next two talk about kind of the issues we were talking about earlier about, you know, who made the decision and the 2165 record retention issue.
Yeah, and we've touched on a lot of this, but the FINRA rules do have certain requirements to keep records about the reason for any disbursement holds, who placed the disbursement holds, who was notified, and records of any internal review that was done. And this kind of goes back to what we were talking about in the last slide about documentation of who you're contacting. We talked a lot about third parties, but it's also very important to document that you contacted government agencies. Write down what you talk to those government agencies about, and kind of shift the ball to their court to figure out who stole the money, who the bad guy is, and how they can remedy the situation.
You know, and then Eric, you know, the last one there's consider the need for an expert, and I think there are, you know, certainly roles for experts to play in these type cases.
And you know, even before you picking the expert, obviously picking your panel is equally as important, Josh. Right. And there are a lot of arbitrators who might have a bias toward or against a dementia case. So knowing the history of the panelist himself or herself prior to choosing them and ranking them helps a lot. And we find that people are often getting the deciding factor in how good their panel is when they're choosing them. But an expert clearly should be brought in well in advance of the actual hearing. Could point out weaknesses in your case along with strengths in your case. And because typically most experts have testified or been involved with enough cases, they can certainly help you down the road in terms of what else you're not thinking of or what you're looking for. So yeah, having an expert early on is always helpful.
Well, I want to thank everyone for coming. We have 30 seconds left, I think, for Q&A. What we'll do is we'll go through the chat and you know, certainly reach out if we see anything that, you know, we weren't able to address. But obviously, feel free to reach out to any of us with, you know, questions or concerns, and we'd love the opportunity to talk to you about these issues. Thanks to the panel, and thanks to our attendees.
Take care.
Thank you. Bye-bye.